Andrade, and this is my injury in fact presentation. And now let's begin. All right, first things first, what is injury in fact? Injury in fact means the invasion of legally protected interest. What is protected interest? Legally protected interest means claim, right, or share, and this claim, right, or share is protected by state and federal law. Thus, injury in fact is an invasion of a claim, right, or share protected by state or federal law. What are the requirements for injury in fact? Injury in fact must be concrete and particularized. This means it has to be solid and it has to be stated in detail. It must be able to be stated in detail. And there also must be a causal connection from injury to conduct brought before the court. Thus, if you're like in a car accident or something like that, you've been clearly injured, right? And if it wasn't your fault for causing the car accident, someone crashed into you, then you must be able to. Then there you go. Then there's your causal connection. Someone crashed into you, and thus you brought that connection to court. And number three, it must be likely rather than speculative. It means it can't be vague or anything, and it must be likely. Is that what that means? All right, so the requirements come from Lujan v. Defenders of Wildlife. These requirements are created from a sort of test, and the test has three requirements, as you can call them. The test is that the injury itself must be an actual injury. It can't just be like something fake or anything like that. The injury must also be real. It can't be based in fantasy land or something like that. And the injury itself also must be something that the law can remedy, the law that can provide some kind of compensation for, if that makes any sense. All right, so in our part one for courts, how courts found plaintiffs to have standing, to begin to understand this, we must understand what a plaintiff is. A plaintiff is a person bringing a case to court. So here's some examples. The first one, this person broke my leg. I'm going to sue him in court. This person is a plaintiff because he experienced an injury, and now he's bringing that injury and making a case in court. He's a plaintiff now. The second one, this word, ran into my car. I'm going to sue him. Thus, he's a plaintiff because he's bringing his case to court because of an injury, an unfortunate injury. So, as long as the injury is particularized, meaning that it can be explained in detail to court, and concrete, the plaintiffs have standing. But what does it mean to have standing? To have standing means to have sufficient cause to stand before the court, meaning that if you have sufficient cause, which means that like you can bring your injury and explain it in detail and it's concrete and you can show it to the court, thus you have standing. And therefore, if you have no cause, you have no standing. And these were, of course, given from Lujan v. Defenders of Wildlife. And the courts found that from this court case, creating this test, it gave plaintiffs a kind of power, and they have standing now. They know what it means to have standing. And this is pretty self-explanatory. What constitutes substantiation of concrete demonstrations of injury? Well, the injury must be plain to see, and the injury must have actually occurred. It can't just be something that doesn't exist. Company obligations in case of data breach. The company has to inform everybody whose data got stolen. The company must also find the source of the breach and patch it, and improve security for later breaches if they ever occur. Here's my references, and that's my presentation. Thank you for watching.